Hi, there are 5 steps forming our own company. Step 1. Under Section 27, Clause 1 of Company Act 2016, which is confirmation of availability and reservation of name, a person shall apply to the registrar to confirm availability of a proposed name. Let's go to the next section, which Section 26, Clause 1, which a name is available if it is a non A. Undesirable or unacceptable. B. Identical to an existing company, corporation or business. C. Identical to a name that is being reserved under this section, or a name of a kind that Minister have directed the registrar not to accept the registration. So, our own company is Ruby Sindiran Berhad. How to determine either Sindiran Berhad or Berhad? Okay, let's go to the next section, which Section 25, Name of a Company. Section 25, 1A, Public Company, which name end of the word Berhad. Section 25B, which state for a private company, the word Sendirian Berhad is applicable. The last one, for the Section 25, Clause 1C, the name end with the word of Sendirian for the unlimited company. So now, let's move to the second step.
The next step, step number 2. In Section 27, Clause 5, upon being satisfied that the name Ruby Sindiran Berhad is not one which may be refused on any ground referred to in subsection 26, Clause 1, and upon payment of the prescribed fee, the registrar may reserve the names of Ruby Sindiran Berhad for a period of 30 days from the date of lodgement of the application, or such longer period as the registrar may allow.
Hello everyone, so now we are in step 3. So in step 3, we are going to look at section 41 of Company Act and section 43 of Company Act. So once the Ruby Sindiran Berhad name is approved and reserved, the company needs to apply for incorporation. So in section 43 of Company Act, the application must contain all these 7 elements. First, company's name. Second, company status. Third, nature of business. Fourth, address of registered office. Fifth, name identification, nationality, place of residence, every company's member, director and secretary. Sixth, share info, and the last one is any other information required by registrar.
Step 4. Section 50 of Company Act. Registration for incorporation. Once it has been certified the requirements have been complied with, Ruby Sindiran Berhad will register the company and assign a registration number.
So now we are in step 5, which is the final step. In step 5, we are going to be looking at section 15, clause C of the Companies Act. Once the registrar has assigned a registration number to Ruby Sindiran Berhad, the registrar will serve a notice of registration upon approval. Under section 19, the notice of registration is a conclusive evidence that all the requirements under this Act have been complied with, and Ruby Sindiran Berhad is duly registered under this Act. With this, Ruby Sindiran Berhad is officially incorporated. Thus, these are the 5 steps of company's incorporation. Thank you.
Okay, next, let's move to the effect of the incorporation. Section 18, Clause 1, upon the date of incorporation, specific in the notice of registration issued under Section 15, there shall be a company by the name and registration number as stated in the principal register kept by the registrar for this purpose.
Section 82. Every person whose name is stated as a member in the application for incorporation and all the incorporation of the company shall be entered as a member in the register of members, together with such other persons who may become members of the company from time to time, are a body corporate by the name stated in the notice of registration.
Moving forward to Section 18, Clause 3. In the case of a company having a share capital, every person whose name is stated in the application for incorporation becomes the shareholder as specified in the application.
Section 18, Clause 4. The details of the register office of the company are as stated in or in connection with the application for registration.
Lastly, the effect of incorporation, the person named in the statement as a director or as a secretary, if any, shall be deemed to have been appointed to that office. Thank you.
Hi, my name is Salomon. I have shoes manufacturing business, but I want to expand my business. So I'm thinking to call my lawyer to get some idea. Hello, Sebastian. I think I want to expand my business, but I don't have capital. What should I do?
Hello, sir. I think you can make a public company. This is because you can make capital through public money by issuing prospectus. And public company needs 7 members. Luckily, you have all in your home. They are your wife, your 4 sons, your daughter, and of course you as well.
Oh, yes. And what about my current business of shoes manufacturing?
Sir, you can sell your business to the company. As the company has a feature of separate legal entity, it can hold the property in its own name.
The company purchased Salomon's business for £38,782. Mr. Salomon took 20,001 of the company's share, which were a payment from Salomon Incorporated for his old business. The company also gave Mr. Salomon £10,000 in secured debenture and rest £5,000 in cash.
One eternity later.
Oh my God! We are in huge losses. Company is ordered for winding up. What is the status of the company?
Let me check. Well, the total assets of the company amount to just £6,050. However, its liabilities amount to £10,000 secured by debentures and £8,000 owing to unsecured trade creditors.
Okay, since I also have my debt, so this asset will be taken by me.
The creditors got angry as they did not have anything and filed a case against the company.
Sir, I am the creditor of Salomon Company Limited. Mr. Salomon and the company are the one and the same thing. As the Salomon had majority of the share of the company and the rest by his family, the losses are also made by him. So, Mr. Salomon should not be given the priority over the asset of the company. And we should get the right over the asset of the company first.
Sir, but the company is an artificial person and has a separate entity. It is distinct from its member, which called corporate will. Since I have owned the secured debenture of the company, I have the right over the asset.
The company is a different person altogether from the subscribers of the memorandum, and though it may be that after incorporation, the business is precisely the same as before. The same person are managers, and the same hand receive the profit. The company is not in law. Their agents are trustees, so the company and Mr. Solomon are distinct persons. And Mr. Solomon, as a secured debenture, will get his right over the assets of the company first.
Yes!
Hi guys, that's are the point of the case law. In a conclusion, a company is a separate legal entity is distinct from its member. This is known as corporate will, and a public company needs 7 members to form.
Constitution of a company. Section 38(1). A company limited by guarantee shall have a constitution. Section 31(1). A company, other than company limited by guarantee, may or may not have a constitution. Section 31(3). If a company has no constitution, the company, each director, and each member of the company shall have the rights, powers, duties, and obligations as set out in this Act. If a company has constitution, the rights, powers, duties, and obligations of the company, director and members are prescribed by the Companies Act 2016 unless by the company's constitution. Also, the company's constitution can modify any of those rights, powers, duties, and obligations only if the Act permits it. Section 32(1). A company may adopt a constitution for the company, and the adoption shall be way of special resolution. Can the date of adoption differ from the date of resolution for the purpose of adopting a constitution under Section 32? Section 32(2). The constitution of a company has no effect to the extent that it contravenes or is inconsistent with the provisions of this Act. Section 32(3). Subject to the provisions of this Act, the constitution adopted under subsection 1 shall be binding on the company, its directors, and its members.
Section 32, Clause 4. The company shall lodge the Constitution with the Registrar within 30 days from the adoption of a Constitution under subsection 1. If a company opted to adopt a Constitution, does the Constitution need to be lodged? The Constitution is binding on the company and the members as if it has been signed and sealed by each member. Section 33, Clause 2. All monies payable by any member to the company under the Constitution shall be a debt due from such member to the company. Under Section 34A, in the case of a company limited by share, incorporated under this Act is a document adopted as its constitution under Section 32. Section 34B. In the case of a company limited by guarantee incorporated under this Act is a document lodged for registration of the company under Section 38. Lastly, Section 34C. In the case of a company registered under the corresponding previous written law is the Memorandum and Article of Association as originally registered or as altered in accordance with the corresponding previous written law.
Section 35. Content of Constitution. First, object of the company. Second, capacity, right, power, and privilege. Third, matters contemplated by Companies Act 2016. Fourth, other matters. A private company's constitution states that the company must have at least 2 directors. Under the Companies Act 2016, allow a company to have a minimum of 1 director. What is the minimum number of directors? A private company must maintain and must the directors be ordinarily resident in Malaysia by having a principal place of residence in Malaysia. Section 36. The Constitution may be altered by passing a special resolution unless restricted by the company. The altered Constitution is binding on the company and the members as if it had been signed and selected by each member.
Alteration of the Constitution must be lodged with the registrar within 30 days from the date of the order. If the company commits an offence, it shall be liable to a fine not exceed 10,000 ringgit. In the case of continuing offence, it shall be liable to a further fine not exceed 5,000 ringgit for each day after conviction. Any alteration which has the effect of increasing the liability of an existing shareholder is not binding on him unless he has given a written consent.
Object clause.
I think I want to deal a contract with Diamond Sdn Bhd. Is it okay? I need Jasmine's opinion. Jasmine, what do you think if I deal the contract with Diamond Sdn Bhd?
Wait, are you already know the object clause of that company?
Object clause? What is it? Can you explain to me?
Object clause is the nature of the company, such as purpose of the company, who company directors, and who the major shareholder of the company. For your information, Companies Act 2016 gave full capacity to a company to carry on or undertake any business and activity. Section 38.3. Company limited by guarantee state its object on Constitution. Section 35.1. Other type of company may adopt a constitution and state there in a constitution.
Is it true I can get the information by registrar?
Yes, of course. You just need to pay the fee to do company search, and as a third party, before you deal with the company, Diamond Sdn Bhd, you should know the nature of the company.